26, Bill C-12 received royal assent, establishing a new administrative reality for the country. The legislation enacts the most extensive structural reforms to Canada's immigration system in decades. The text itself outlines its operational focus. It is formally titled, "An Act Respecting Certain Measures Relating to the Security of Canada's Borders and the Integrity of the Canadian Immigration System." This new law rewires the administrative state across three distinct operational vectors. First, it centralizes discretionary executive power over immigration applications and documents. Second, it restricts the asylum pipeline through the enforcement of strict retroactive eligibility clauses. And third, it legalizes the expansion of transnational data sharing networks. For legal professionals and policymakers, understanding this framework is no longer optional. It is the new mechanical baseline of Canadian administrative law. The legislation shifts the locus of centralized control directly to the Governor in Council. The Governor in Council is the Governor General acting on the advice of the federal cabinet. This body now holds sweeping executive authority over the processing of immigration applications, the validity of immigration documents, and the status of temporary residents. This flowchart illustrates the first branch, the power to seize, suspend, or terminate the processing of any application. The second branch allows varying or canceling existing documents, including work and study permits. The third grants power to alter conditions on temporary residence. The legal threshold required to trigger any of these powers is a determination that the action is in the public interest. The bill explicitly defines public interest to include matters pertaining to administrative errors, fraud, public health, public safety, or national security. The sole structural counterweight built into this section of the Act is a requirement for the Immigration Minister to submit mandatory reports to Parliament detailing the impact of these executive orders. This structure moves the Canadian immigration apparatus away from predictable, codified processing criteria and toward a model of dynamic, discretionary enforcement. The second vector of Bill C-12 enacts a severe contraction of the asylum framework by severing long-established procedural pathways. This diagram shows the new operational logic gate that all incoming asylum claims must now pass through. The first exclusionary gate determines time of entry. Asylum claims made more than 1 year after entering Canada are now ineligible. This 1-year time limit applies strictly to individuals who entered Canada after June 24, 2020. The second exclusionary gate screens for the method of entry. Claims made by individuals who crossed into Canada outside an official port of entry, irregular crossers, are also ineligible. Under the previous Immigration and Refugee Protection Regulations, claims from irregular crossers were permitted, provided they were filed at least 14 days after entering the country. Hitting yes on either gate has an immediate consequence, bypassing the Immigration and Refugee Board entirely. Instead, ineligible claims route to a secondary mechanism, the Pre-Removal Risk Assessment, or PRRA, a formal evaluation determining if an individual faces persecution or risk to their life if deported. These new ineligibility gates apply retroactively. Any claim made on or after June 3, 2025, the date the precursor Bill C-2 was introduced, is subject to these rules. For the eligible claims that do reach the IRB, the board is now legally prevented from proceeding if the claimant is not present in Canada. Furthermore, claims must be deemed abandoned if the individual voluntarily returns to the country from which they are seeking protection. An amendment introduced by the Senate requires the Immigration Department to report to Parliament the exact number of claims routed into PRRAs, specifically because of the new 1-year ban. This is a structural rerouting. A massive subset of individuals is now diverted into a mechanism operating under entirely different procedural constraints than the standard IRB pathway. Part 5 of the bill dictates the third vector, expanding how the state handles individuals' personal information. This maps the authorized data flow. The Immigration Department can share personal information with other government agencies, including crown corporations. Those agencies can then disclose this data to foreign entities. The only condition for this international transfer is explicit permission from the Immigration Minister. The scope of these provisions sparked a specific legislative dispute over exactly whose data is swept into this pipeline. On March 13th, the Senate introduced an amendment attempting to explicitly exempt the data of Canadian citizens and permanent residents from these information-sharing provisions. The House of Commons rejected this amendment, and the Senate subsequently agreed to its removal. The final law ensures that citizens and permanent residents are not insulated from the network. The result is a legalized, borderless pipeline, allowing domestic demographic data to reach foreign entities, constrained only by the requirement for ministerial permission. This complete system map represents Canada's new immigration apparatus. It combines the executive flowchart, the asylum logic gates, and the transnational data network. The overarching transformation is clear. Canada has moved away from a highly procedural, board-mediated framework. It has been replaced by a system defined by rapid executive discretion, heavily restricted intake pipelines, and a continuous transnational data flow. The adopted bill does include one final safeguard introduced by the Senate to monitor this shift. A parliamentary committee is mandated to review the bill's total impact and present recommendations for changes in exactly 5 years' time. The true friction of this legislation will occur when these abstract, sweeping executive powers meet the complex physical reality of human migration at the border. For scholars, policymakers, and legal professionals, mastering this new operational reality is the unavoidable baseline for navigating Canadian administrative law over the next decade.